Welcome back to TWOgether for another exciting episode with my friend Bill Mew. Bill, do you think that we need a superhero for privacy and digital consumer rights? And if so, who would that be?
Well, we already have a framework, a magical framework that is there to set out our privacy rights as the same way that we have a United Nations agreement on what our human rights are. And the one setting out privacy rights is GDPR. And it has become the global standard to which most other regions are seeking to match their regulation. And we've seen similar regulation in California, in South Africa, and a whole host of different countries, very much in line with GDPR. But GDPR set the gold standard and set the original stake in the ground on behalf of consumers. And when it arrived, it came with some very big headlines. And most of the headlines at the time that it was announced were all about fear and fines. So obviously, companies are bound to be held to account, and there's going to be loads of enforcement to make sure that companies don't think lightly about privacy and security.
Well, that is the plan, of course, but what is actually happening on that, Bill? I know that there's a lot of developments, and I know that you are highly involved. So please give us some info about what the actual power and impact of GDPR is so far.
Well, the original headlines may have been all about fear and fines, but in reality, what we really need to see is a culture and a behavior within organizations where they're going to take this kind of thing seriously. And if they do take it seriously, then they will adopt a protective attitude towards our personal data, and there shouldn't need to be much enforcement. However, if when there are transgressions, we have very little in the way of big fines or even any kind of enforcement against these organizations, then there's going to be little incentive for other companies to spend a lot of money or spend a lot of focus on investing in their own privacy. So we need to look at not only culturally, how has this changed people and the attitudes across the board, but what has been the reaction to some of the big incidents or the transgressions?
I'm happy that you mentioned across the board, because from my perspective, privacy and digital consumer rights should be something which is docked at the board of directors, or at least at the senior executive leadership team. From what I see in the market and the companies I work with, I do not see that. I do not see that boards and executives see it as an opportunity to grow business by providing a good protection of privacy and digital consumer rights. What are you saying?
That's very interesting. And part of the reason for that is that GDPR was meant to lead to a massive change in behavior. What GDPR actually did was lead to a certain amount of awareness, and a lot of people saw when it came in that there were lots of privacy notes flying around, and the level of awareness of privacy went up enormously. But the behavior didn't necessarily follow through. And in many organizations, the responsibility for GDPR was handed to a data protection officer, a bit like the way that cybersecurity is handed to a chief information security officer. And once delegated, most of the board level people think, oh, that's fine, we've dealt with it, and they forget about it. That's not going to lead to the sort of change of behavior, the sort of digitally ethical cultural orientation that we're looking for. And it's been a massive disappointment. And one of the reasons for this is cultural, in the way that most organizations are set up and managed, and the way that people within those organizations are incentivized. Unfortunately, as creatures, human beings tend to take risks. And there are any number of people who take ridiculous selfies and fall off cliffs and do all sorts of crazy things. And we've heard some of those news of people taking ridiculous risks. This is endemic culturally in most of our attitudes. So if you look back to the financial collapse of 2008, the reason all of this happened, and people were looking and seeing all the signs were there, and anyone could have said, well, subprime mortgages, that's a nonsense. It's about to blow up in your face. The way that they were securitizing programs, that was bound to blow up. But the individuals were all incentivized on revenue and profit. And if you go and look at almost every executive and indeed every employee within most organizations, they are incentivized by revenue and profit. These are ROI measures, return on investment. There's possibly only a few people within the organization who have an ROR focus, return on risk, and that would include the data protection officer or the CISO. The CISO has a budget where he is told, this is our risk appetite, this is how much you can do. With this budget, can you match our risk appetite, and can you reduce our risk as much as possible? There's possibly a limitless amount that you could spend on information security and privacy, and you're not going to do that. So you need to set your risk appetite and act accordingly. And that's a sort of ROR approach. Unfortunately, the DPO or the CISO are almost the only people within an organization with an ROR focus rather than ROI focus. So therefore, companies, the way they're set up, aren't going to behave the way that we want to. And we saw that with the financial collapse. We saw that when health risks first arrived at the beginning of the pandemic, and something could have been done early on. People did not, they weren't sufficiently risk aware in the way that they behaved. And we will see this in future. We're seeing this with climate change. People aren't sufficiently risk aware to deal with the climate crisis and the challenges that have early enough. And at some point in the future, the next big pandemic, I predict, will be a cyber pandemic, and we will all be hit. And that will be a reflection of the fact that we didn't have enough of an ROR focus. So I'm a massive champion for saying that organizations need to change culturally to have a balance between ROI and ROR, so that they're not totally focused on not totally focused on revenue and profit, and that they also have an awareness of risk. Now, if companies aren't going to do this, then who is going to be our superhero? Who is going to step in and hold those companies accountable? Could it be the regulator, do you think?
Well, I thought it was going to be the regulators, Bill. I thought when GDPR came, and not that much after that, CCPA basically followed suit and made a model which is somehow molded based on GDPR. I thought we finally have the superhero. There is going to be a regulator. But it turns out that is not the way not working the way we expected. And we see that especially with some of the recent rulings and decisions, Bill.
Well, the way that things have actually played out, unfortunately, has been that given the nature of the regulation, it is a Europe-wide regulation, so it therefore falls to the local regulator in each country to regulate some of the companies that are based there. Now, it happens that a lot of the really large technology companies, such as Facebook and Microsoft and Amazon and all of the big names, happen to have their European headquarters based in Ireland, and therefore a disproportionate responsibility falls to the Irish regulator. Now, obviously, if you were to say, name a company that you felt had been particularly egregious in its use of our data, a company that would typically come to mind would be a company like Facebook. It's had numerous privacy incidents. It's had a lot of fines and from various different sorts for small incidents in the past. When you come to look at how it's fared under GDPR, it's fallen to the Irish regulator. And the Irish regulator has something like a couple of dozen major cases against some of these big tech firms. And more than half of those cases are against Facebook, because Facebook has particularly been in the firing line, arguably because it's been particularly woeful in this respect. Then when you say, well, how has the enforcement gone and how effective has it been? And the disappointment starts to arise, because one of the main challenges about Facebook in the way that it does privacy was brought by a gentleman who I know well and who's a friend and somebody who I have enormous respect for, called Max Schrems. He brought a previous challenge against Facebook in the European High Court a number of years ago, which he's famous for, and that overturned the existing privacy arrangement at the time called Safe Harbor, which was then replaced by Privacy Shield. Now, both Safe Harbor and Privacy Shield are treaties signed between Europe and America about giving an equivalent so that when our data is handed to a company in Europe, it is protected under GDPR. But obviously, if that's data is taken offshore to a third country, be it the US or wherever, then we need to be sure that when it's taken there, it's treated with the same respect. And we can come on to another program to talk about Privacy Shield and the dynamics with America and some of the laws over there. That's probably an argument for another time. But Max more recently brought a case again against Facebook under GDPR. And you would have thought that the Irish regulator, with a number of outstanding cases against Facebook, would have taken this seriously and would have acted as a champion for us all, the superhero that we're looking for. Unfortunately, rather than picking up its cape and taking on that superhero role, the Irish regulator sought to step back, and it actually brought a case to the European High Court where it challenged both Max Schrems and Facebook. Effectively, what it was doing was seeking to avoid responsibility and to avoid having to do the enforcement itself. In doing so, it chose to go down the commercial legal route, which is a more expensive route to take. Some would argue this might have been in an effort to make it too expensive for Max as a private citizen, and supported by a fundraising effort for his non-profit organization, which we're both members of and we contribute to. You would have thought it was an effort to try and price them out of the game, to make it too expensive for them. Thankfully, they had enough support from us and many others to bring that case, and it came before the court over a number of different hearings, and finally came to a head in July this year, 2020. And Max was successful in bringing that challenge against Facebook. Now, Max didn't seek to overturn Privacy Shield. He didn't seek to overturn standard contractual clauses. And again, when we talk about the transatlantic thing in another program, we can go into an effect to see what the ongoing implications of this are. But part of what he did, in addition to those happening, the regulator, or the European High Court, said to the Irish regulator, you were wrong to take this route. You should have acted and enforced the regulation yourself, and gave them a large kick up the backside and told them to get on with it, and that it wasn't optional and they needed to actually do their job. And that is the problem that we've had. And the Irish regulator hasn't been alone in failing to do its job. I think we've seen some more headlines recently in the UK, haven't we?
Exactly, Bill. And I think that brings us to a good point to end this episode for today. We have learned that we apparently do need a superhero, but unfortunately GDPR, due to the way how it is executed by the regulators, is not yet that superhero. In the next episode, Bill, I will ask you if maybe our friend and respected advocate for privacy, Max Schrems, is that superhero or going to be. So stay tuned. I will have a lot of questions for you on this topic, Bill. Thank you.